God save the United States of America, the state of Tennessee, and this honorable court. Please be seated.
All right, good morning, everyone. We are so pleased to be here to have the Tennessee Court of Criminal Appeals here at the University of Tennessee at Chattanooga. There are a lot of people I want to thank, but first I'm going to introduce our panel. Can y'all hear me okay? All right, to my right is your local celebrity, Judge Tom Greenholtz, very proud UTC alum and a great member of our court, obviously here from Hamilton County. On my left is Judge Kyle Hickson, who's from Knoxville. And all three of us were trial judges before we came onto the Court of Criminal Appeals. And as I said yesterday, I realized we were all three UT law grads. So we are so happy to be here. And I'm Jill Ayers. I'm from Clarksville, Montgomery County, Tennessee. And so I'm from the middle. These two guys are from the east. Our court kind of rotates around, and that's one of the benefits of the Court of Criminal Appeals. So there's so many people here that we want to thank today, and I hope I don't miss anybody. First of all, we're just thrilled to be in this beautiful location. If y'all get bored listening to us or the lawyers, you've got a fantastic view behind us. We're used to being in a courtroom with no windows, so this is truly and absolutely a pleasure. So we really want to thank the leadership of UTC, including Chancellor Stephen Angle, all the administration and the staff who have made this possible. Brett Fuchs, Lieutenant Nathan Hartwig, UTC Police Department, including Chief Sean O'Brien, and then also the library leadership, which includes Nora Catron, Bo Baker, Michael Andrews, and Dr. Deerdorf. So there takes really a team to put all this together, and their commitment to this process has really made this possible. We've got a lot of folks who've traveled with us, with whom we could not do this without their involvement. And that includes all of our court staff from the AOC, doing our live stream, Jim Hivner, our clerk, and all of his staff, and the staff from the Knoxville clerk's office, as well as Judge Greenholt's law clerks, who have been really helpful in this process. And then finally, to the students who are here today, we want to thank you. I don't know, maybe you had an option, maybe you didn't if it's class credit, but you're here, and we appreciate that you are here, and we appreciate your interest in this process. Hopefully, getting to watch this up close and firsthand will give you a better understanding of the law and the application. I'll go over this again later after we complete the arguments in each case. We're going to take a recess, and the attorneys are going to stay around, and students will have the opportunity to ask questions of the attorneys about the case. We can't discuss the case, so that's why we're going to excuse ourselves for that part of the process. Did I forget anybody? Okay, awesome. So again, we're just so happy to be here. We'll get on with the process. As each side knows, you have 20 minutes per side. If the appellant wants to reserve any rebuttal time, let us know on the front end. Thanks to the Knoxville Clerk's Office, we've got our timer here, so that will help you keep up with that. And are there any preliminary matters?
No.
All right, then if you'll call the first case, Mr. Hivner.
State of Tennessee versus Billy Norman Forte.
Good morning, Your Honor. William Neal, on behalf of the appellant, Billy Forte, proposed commission hours of 4 minutes to rebuttal. As a preliminary note, the court, consistent with the briefing, I will refer to my client, the appellant, as Mr. Forte, and will refer to his Charles. I do so simply to avoid confusion because I think she is the same last name. Your Honors, it's undisputed in this case that Mr. Forte shot and killed his son, Charles Forte, on the day in question at East Formal Ware, which was a business owned and operated by Mr. Forte. That is not in dispute. That was not in dispute at the trial level. What is very much in dispute in this case is the mental state of Mr. Forte. The most important action in this case, legally, was what was going on inside Mr. Forte's
side suggests that even if there had been a negligent failure to preserve his 911 phone call, that among other things, there was good substitute evidence of what happened in that phone call, not least of which was your client's statement to law enforcement authorities that occurred shortly thereafter. What is it about the nature of the phone call itself could not be remedied with the defendant's own statement to law enforcement made shortly thereafter?
That raises a few points. Number one, it is true that when law enforcement arrived on the scene shortly after Mr. Forte placed the call, one of the arresting officers asked Mr. Forte something to the effect of a Bible treatment. Mr. Forte attempted to start to explain. He did not get one sentence out before the officer told him to, quote, shut up.
But there was a second statement, a longer statement given by your client, isn't that right?
Correct, Your Honor, that did not occur much later. And so there was an initial statement at the scene, which was foreclosed, shall we say, by the officer. And I don't mean to quibble, the officer, he was trying to secure the scene and so forth. But we cannot say that Mr. Forte was given an opportunity to make a statement when he was told to shut up.
So is the value in the 911 phone call, is that limited to, this is happening immediately after the shooting, I'm telling my version of events immediately after the shooting, is that the value of the 911 phone call?
Your Honor, it's not just that he's telling his version of events. This court held in the State versus Nicholas Johnson, that the case, that the best evidence of the defendant's state of mind following the killing is a recorded statement he made immediately after that. And as you get more remote in time, the value diminishes.
Okay, so how much further remote in time was the longer statement that the defendant gave to law enforcement?
Several hours.
Okay, still the same day?
Yes, Your Honor. Later that night, I'm not sure if midnight passed.
Sure. What was he not able to communicate to law enforcement that would have been in the 911 phone call?
Well, what you don't get from a longer statement later on is what is the nature of the type of evidence. Because what this court has held is the reason it's the best evidence is because you get the demeanor. You get the closest you can in a case like this to a window into the mind of someone at the time of the killing when you hear a recording of it right now.
Okay, so the defendant testified at trial. Was he not able to communicate that to the jury, what his demeanor was at the time, what he was thinking, what the circumstances were? What else would the 911 phone call have added to his testimony at trial?
What we would say, Your Honor, is that him describing the 911 phone call, and first of all, his memory, that at this point would be years later, so the evidence is extremely valuable. His memory of that call was important. Mr. Forte had suffered a stroke a week before the events of this case, and so a lot of factors go into that. And the most important thing, though, is that his description to the jury during his testimony many years later is simply not the same.
Value of the 911 phone call, really, when we boil it all down, it's just corroborative evidence. New substantively is not adding anything new by way of description of events that couldn't be solved in the initial statement to law enforcement officers an hour later, his trial testimony. It simply is there to corroborate what he's telling the jury. Is that really what
We're not saying just to corroborate, but rather to help resolve his state of mind, which is something that was a matter of circumstantial evidence. And the evidence on that was very ambiguous. The person who was in the room, Ms. Pearson, I hesitate to call her an eyewitness because she's not looking at me. So we have a situation where we're just looking at inconclusive, imperfect, circumstantial evidence about Mr. Forte's state of mind. Again, this court has held that the best evidence is a recording of a defendant immediately after that killing, and the jury was deprived of the best evidence.
So he's entitled to a fair trial, not a perfect one, right? Why is it that dismissal would be the preferred remedy here when there is other evidence of his intent, when there is other evidence of what he observed, when there is other evidence of what he believed? Why would dismissal be the remedy rather than the jury instruction of the trial court?
Well, Mr. Cole, as a response to that, first, and this goes to something you mentioned earlier, that the state was able to put on substitute evidence. The state was able to put on evidence that Ms. Pearson walked out of the room because she was scared, and she walked back into the room to retrieve her cell phone.
the evidence at issue in that case?
In that case, it was a vandalism case, and so the state had failed to preserve physical evidence that had to be
Okay.
I believe it was traffic light.
So we're not talking about a failure to preserve a defendant's statement when the defendant gives another statement hours later and is testifying at trial.
Not exactly in that regard, Your Honor, but similar in the analogous we would submit in the sense that the state would be able to submit a more favorable substitute evidence. And what this court held with that is that this was not required, but the jury instruction was not enough. And so what they held was that the appropriate defendant's state which was exactly what the state was doing. And so that would provide the ground for the to decide that a jury instruction is insufficient, that this dismissal would be too much. And for that reason, we would ask the court to consider first dismissal and then alternative, shall we say, middle ground.
Can we turn to the time frame a little bit? If the evidence was that critical, from what I understand from the record, it was 3 years later. I mean, the 911 call actually existed for a period of 3 years, and yet the defendant never sought to obtain it, and really didn't even, I'm not even sure if they even knew it existed or didn't exist. So talk to me about why that's not a problem for your client.
Sure, this does get into a little bit of the weeds about how this goes. First of all, although the state may disagree with this, I'm not sure it's entirely clear that a person can get that out of the in the usual course of proceedings, this is turned over to discovery. That is how this goes typically.
But even if that's the case, how did they not know they didn't have it?
I mean, it's subject to an Open Records Act request, right? I mean, it's here in Hamilton County.
Get into this too much, but
Yeah.
there have been issues in other cases where such open records requests have been tested.
Okay, all right.
Especially with video and crime, there's exceptions that come into play. And so I'll just leave it at that. It's not entirely clear that Mr. Forte could have gotten it on his own.
Did he attempt? Oh. Did he make any attempt to do that?
There is no indication in the record of any attempt to do so. Again, for the surgery trial expectation that the 911 call would be used. And so I believe the way that this occurred was that when the state at some point during that period notified the 911 call center, the agency that would be meeting that, and the call preserved Ms. Pearson's and when they were put over into discovery, it's not apparent that Mr. Forte's trial counsel was immediately aware that there was another 911 call, but Mr. Forte, who is this court may know, engages in some person advocacy, brought it up. And at that the issue was so it took some time for that to occur. There may have been some confusion as to whether or why the recording had not been captured. It eventually came out in testimony that the 911 center was a process for 911 calls to wait. So as you can imagine, if there's a crime involving a gunshot, you might get many 911 calls. And so those calls are supposed to be linked in the system so that they're all preserved and that not happen.
So going back to Judge Ayers' answer, Judge.
Go ahead,
I
Colin.
was just going to ask, when did the state's discovery response, how did that relate to the timing of the 3-year instruction period? Was it before or after?
That occurred, the state at least communicated with the 911 center and preserved the other 911 calls sometime during that period. And then its discovery response occurred either just before that or after it expired, such that by the time this was all hashed out, they had already destroyed it.
Counsel, back to Judge Ayers' question, though. She was asking, I think, in terms of the 3 years. When was the request made by defense counsel for this evidence, either pursuant to Rule 16 or otherwise? Is this a situation where defense counsel did not request the 911 phone calls, or did not request that they be preserved, and we're just depending upon the state to turn it over without a request?
I believe they were depending upon the Rule 16 request.
Was a request actually made? Is that in the record? Okay, when was it made in relation to the 3 years?
I'll have to look at the record to verify this. I believe that by the point that, I believe that the request was made. Delayed early in the case. Because of that, I believe the request was made after the 3-year period.
Okay, so the first time the defense counsel was making a Rule 16 request, 3 years into litigation, after the evidence started to be destroyed.
I will
You're saying it's the state's negligence?
Yes, Your Honor, because the state knew that there was a pending first-degree murder case that was going to be litigated.
Ferguson depends upon Rule 16, and we're talking about the duties reserved that arises under Rule 16. Rule 16 is triggered by a request from the defense counsel. If no request is ever made in a 3-year period, how do we even get over the threshold first?
I'll say, Your Honor, given the way that the trial proceedings happened in this case, Mr. Forte's trial counsel did make a timely Rule 16 request. The state was under an obligation to preserve potentially exculpatory evidence during that time period, and that duty extends to law enforcement. It also extends to someone like an agency like a 911 call center. And so, for that reason, the Rule 16 request was timely, irrespective of how it was timely based on the rules of Rule 16, and based upon the usual course of proceedings, trial counsel had every reason to expect that it would be preserved that way. I believe I may be out of time, so I'll just briefly conclude by asking that this court reverse the judgment of the trial court and order the dismissal of this case for the alternative legal case for the trial.
Thank you.
General Coleman? Okay, hold on 1 second. We're going to have a little mic adjustment.
Good morning, Your Honors. May it please the court. Is this working? Your Honors can hear me, then we'll go from there. Ronald Coleman on behalf of the state. This court should affirm the judgments for 2 reasons. First, to the extent that there was a Ferguson violation, the trial court properly exercised its discretion in determining that the appropriate remedy was a jury instruction. And second, the trial court properly exercised its discretion in making evidentiary rulings. My friend on the other side wasn't able to get into the evidentiary rulings, so unless this court has any questions on those, I'll address the Ferguson claim. But before I do, because we have people in attendance who might not know the facts, I want to do a brief factual background. So on April 2nd, 2018, the defendant shot and killed his son by shooting him with a shotgun in the head. The defendant was charged with first-degree premeditated murder, but was convicted of second-degree murder. The victim, the defendant's son, worked at the defendant's company, and earlier in the day, the defendant had gotten into an argument with the victim. Later that evening, the victim had called a coworker to come to the business to help him out with a computer problem. And a few minutes after that coworker arrived, the defendant came into the room, asked a question, something along the lines of, did you end up helping that lady, or something about a lady? And the victim responded in the negative. The defendant then left the room, acquired the shotgun, and came back in the room before shooting his son in the head. He told police that he shot the victim because of bullying. He said that the victim had, quote, pushed him too far, and that you don't push and bully me. And then he even said that the victim made his own bed. And he made several other damning statements during a police interview when the police had stepped outside of how he's going to get the jury hung, and it's a jungle and you take care of things yourself, things along that nature. But later at trial, he insisted that the victim always carried a pistol and that he, the defendant, was simply defending himself when the victim lunged for that pistol. The jury rejected that claim and again convicted the defendant of second-degree murder. So the issue on appeal is whether the trial court abused its discretion or whether some additional remedy was necessary for a Ferguson violation. I'd like to sort of plot this out again because there are people in the room who might not understand exactly what we're talking about. So, due process mandates that defendants have a fundamentally fair trial. And when it comes to the preservation of evidence, there are a couple of steps. There are really 4 steps that this court looks at to determine whether that trial was in fact fair. First, did the state even have a duty to preserve the evidence? Second, if they did have a duty to preserve, did they fail in that duty? Third, if they failed, did that failure somehow result in the defendant not having a fair trial, or would it result in the defendant not having a fair trial? And then if it would result in the defendant not having a fair trial, what is the appropriate remedy to ensure that there is a fair trial? So the first 2 steps, did the state have a duty to preserve? I think, I know your honors asked questions about public records and things, but I think the trial court found, and it reasonably makes sense, that the state recorded this, had control over it, they probably had a duty to preserve. Second, did the state fail in that duty? I think it's reasonable to say that they did. So your questions about the timeline, I want to make sure we get the facts clear. So the defendant shot and killed his son on April 2nd, 2018. The indictment was returned 4 months later in August. That same month, and to your point, Judge Greenhalgh, my recollection is that the record doesn't include a Rule 16 request from the defense, but it does include a trial court's order for the state to comply with the rules of discovery and turn things over.
And can the trial court require the state to produce evidence under Rule 16 in the absence of the defendant's request?
I'm a little shaky on that, Your Honor.
I mean, for example, let's say that I did not want, as defense counsel, I did not want to disclose my expert. And if the trial court is ordering that the state provide its expert, I have a duty now to disclose what I have.
I think to your Honor's question, the reciprocal duty for a defendant to have to comply with Rule 16 requires that they make the request. Whether the court can order the state to turn things over without imposing any burden on the defendant, I think I'm just not sure about that. But either way, the state complied with that. Again, roughly 4 months after the shooting. Then 3 years went by. And to your Honor's questions, when did the defendant request this or point out, hey, I made a 911 phone call. I've known about this since I made the phone call. He didn't point it out until 3 years and 2 months after that phone call. Just happened to be 2 months after the 3-year destruction or retention policy of the 911 police department.
So if within 4 months of the homicide occurring, the trial court is already ordering the state to produce evidence, when does the state produce the 911 phone calls it's aware of?
The record isn't entirely clear as to that, but I would submit sometime within that same month or just a short while after. There are no complaints. The defendant hasn't said, doesn't file anything saying, I've never received discovery.
So it's not a motion to compel that's been filed?
No, Your Honor. So at some point, pretty early on, the state complies, and then again, the defendant waits 3 years. But if we're looking at the 2 factors, if we want to just assume for the sake of argument, state had a duty to preserve.
Why would we presume that, though? Because I'm struggling with that on how this timeline is worked out, and especially considering the fact we're talking about a 911 recording, which, as far as I know, would be a public record, something that's held not necessarily in a law enforcement office, but in a municipal 911 communications center. Why does the law not require the defendant to take some reasonable steps during that time to procure that evidence, especially if it's so critical to the defense as it's been presented?
Well, Your Honors can certainly go ahead and decide on that basis. I can't think of a reason not to. And so if Your Honors wanted to go. The trial court did make that finding, but this court, when reviewing whether the trial was fundamentally fair, which I think these considerations go to, this court reviews it de novo, which means it's a fresh plate. It doesn't matter what the trial court did. This court can make up its own mind. So if this court wanted to determine that there was no duty to preserve put on the state because the defendant could have accessed those records in the 3 years that they were maintained, then the state encourages it to do so. But if it wants to go along and uphold the trial court's findings of a duty to preserve and a failure to do that preservation, then we get to the third prong, which is, did that failure to preserve possibly render the defendant's trial unfair? And there are 3 factors that this court looks at when making that determination. Again, that determination is also on de novo review. So this court, even though the trial court determined that it would have been rendered fundamentally unfair, this court can decide otherwise. And here, the first problem that you look at is the degree of negligence on the state. And to your Honor's points, that degree of negligence was minimal at best. The state, as my friend on the other side acknowledges, there was no malicious intent here. The state complied with its retention policy. The police had a 3-year retention policy, and the reason that this one got destroyed was simply because the 2 calls didn't get linked. The defendant called 911, Ms. Pearson called 911, when the police responded, each 911 call created its own report incident number. When police responded, they put all their notes and all of their statements and everything on Ms. Pearson's incident number for her phone call. And then the defendants just simply didn't get linked.
So your friend on the other side says, look, we're not arguing that it was intentionally destroyed, and so we don't have the heightened guilty mind here. He suggests, though, that when the trial court found it was negligent not to preserve it, that the negligence could have been simple or gross. And he argues that it was gross negligence because the 911 center is not following its own policies. And so it's not just a simple, hey, we didn't link these at the time, it's we did not follow our policies, and that resulted in the destruction of evidence. Why is it not gross negligence?
So first of all, I think when this court reviews the trial court's comments, even though the court didn't say the degree of negligence was minimal, the context of it makes clear that the court thought it was rather small or minimal negligence. And the reason it's not gross negligence is because there was no conscious action to do this. This simply fell through the cracks. They did not realize they were linked. And in fact, the police department did follow their policies. They retained it for 3 years in accordance with policy and then deleted it in accordance with policy.
Of course, negligence never requires conscious action, right? If we have conscious action, then we have knowing misconduct. If we have conscious action, we have intentional misconduct. Conscious action is not something we typically think of as gross negligence, is it?
But even with the cases that the defendant cites, when this court has found gross negligence, it effectively is a conscious decision. It's where police had evidence that was used in trial A, and before it got to trial B, they just destroyed it. And they act like they knowingly destroyed it. So
all things being equal, if this court were to find that it was grossly negligent, not to link the 911 phone calls so as to preserve them, would that weigh in favor of a remedy different than a jury instruction?
I don't think so, because that's one of the 3 prongs. So even if this court finds that the negligence wasn't minimal and was instead gross, was high, then we go to the other factors. And the second factor is there substitute or secondary evidence? And to your point, Judge Greenholz, there was an abundance of substitute or secondary evidence. There was the CAD card, which made notations of the comments that the defendant had given to the 911 dispatcher. There was also Ms. Pearson's testimony, which is where she came back into the room and heard the defendant say, I need somebody to come down here, I shot this boy. There's also the defendant's statement to police twice. And first, immediately after police arrive on the scene. And to be clear, I don't think the defendant was cut off. Instead, based on the body cam footage, the officer asks, why did you shoot him? Or why did you shoot him? The defendant says something that can't be heard, but completes that sentence, and the officer's response is, well, you shot him over that. Not shut up, not be quiet. Initially is, well, you shot him over that, and that's on page 214 of the record. And then that same night, I want to say it's within an hour or 2, but the record will be more accurate. Sometime that same night, he gave a statement to police. And then finally, the substitute evidence we have is the defendant's own testimony at trial. When you have that accumulation of substitute evidence, and when you're weighing that wrong, that weighs heavily in favor of finding that the trial remains fair. And then the third prong, when you're just looking at the fairness of the trial, is the substance of the evidence. And the evidence here was overwhelming. Again, all of these comments, the defendant's own actions of going and obtaining the gun. So his claim was that this shotgun was always in the shop, and I just walked next door to grab it. Ms. Pearson said she'd never seen it in the shop. The defendant's own wife testified that the shotgun usually remained in their house in a closet, and then police found a rifled cloth bag out in the parking lot, which indicates the defendant went and secured that weapon before coming to shoot the victim. When the evidence is that overwhelming, all 3 factors we submit weigh against a finding that the trial would have been fundamentally unfair without this 911 phone call.
When we weigh these factors, is there any room in Ferguson for us to consider how this evidence would have been used from an evidentiary standpoint at trial? And what I mean by that, I know Mr. Gill mentioned, he seemed to contend that this was an excited utterance, 911 call. Of course, we're talking about a recording of a statement of the defendant, which you would generally consider as being self-serving hearsay if it was offered by the defense. Is it appropriate for us under Ferguson to think about that and think of a hypothetical where the state said, hey, I don't think this is trustworthy, I think it's self-serving, I'm not going to put it in my case in chief, and then what does the defendant do with this evidence had it been preserved?
I think that's certainly a factor for this court to consider. I think it's almost a totality of the circumstances under the third prong of would this have come in, how would it have come in, and then what impact would it have had when you weigh it against everything else. And so I think this court can consider that in determining that this trial was not rendered unfair based on destruction of that 911 phone call. But even if this court decides that the state did have a duty and that this would have been rendered fundamentally unfair, the trial court properly exercised its discretion in determining what the appropriate remedy is. And when we're looking at what that remedy imposed was, the standard of review changes. So this court is now acting in deference to the trial court. Who's sitting there, who's watching the trial, who's sort of the boots on the ground. This court gives deference to that. And in order for it to overturn that, to say that a different remedy was appropriate, this court has to find that the trial court applied an incorrect legal standard, reached an illogical decision, or that it based its decision on an erroneous assessment of the evidence. The defendant hasn't alleged any of those three here, and the state submits that he can't because the trial court gave a well-reasoned basis for why it was determining that a jury instruction was appropriate. It considered this, and it found that this trial might be unfair without the 911 call, but dismissal is completely unwarranted and is unnecessary. I believe it called it unreasonable to dismiss the case, and instead it found that a jury instruction was appropriate, and it gave that jury instruction. It told the jury, hey, the state had a duty to preserve, and if you find that they failed to do that, if you find that they did not preserve this 911 phone call, you can consider that it is favorable to the defense, that it bolsters his testimony, that it makes him more credible, that it goes towards his defense. And the jury was told that. We presume they followed these instructions, and they nevertheless found that he was guilty of second-degree murder instead of acting in self-defense. So there are really at least three different ways that this court can affirm the trial, or affirm the judgments, either by finding the state didn't have a duty to preserve, by finding that the failure to preserve did not render the trial fundamentally unfair, or by finding that the trial court acted reasonably, acted within its discretion in determining that a jury instruction was appropriate. I think that's all I have. If this court doesn't have any further questions, we respectfully ask that you affirm the judgments of the court. Thank you.
I think we maybe took a little of Mr. Gill's rebuttal time. How much did he have left, Mr. Whitmer?
3 minutes.
Okay.
Mr. Gill, can I take a little bit more than
I may give you a little more back. We'll see how that goes.
We can negotiate. That's right. Interesting hearing your friend's argument on the other side about really what is fundamentally an issue here. Let me posit a hypothetical too. Let me say that the defendant's 911 phone call was never destroyed. It wasn't linked by the 911 center, but it was never destroyed. It was always preserved. Parties don't ask about it. For whatever reason, Mr. Forte doesn't ask about it. And you go to trial without the 911 phone call. Would that be a fundamentally unfair trial at that point?
Just think about that for a second. What I think distinguishes that hypothetical is that in that situation, even if the phone call is potentially stolen, in that situation, the state has not reached the duty. Okay, so that changes the scenario. That changes the due process situation because the state has not reached its duty to preserve potentially exculpatory evidence.
So in that situation where there's simply a failure to link, but the 911 phone call is still preserved, there's no Ferguson issue, or maybe Rule 16 issues, maybe the other discovery issues, no Ferguson issue.
And in that situation, I think other doctrines would come into play because at that point, maybe the trial court would consider it continuous because you can still get your phone call. It's not gone from the different considerations come into play when it's so favorable. And then you really might look at things like the diligence and seeking and so forth.
So even though the trial would be exactly the same, the trial would be exactly the same evidence, the mere fact that the evidence was destroyed and not available as opposed to no one requesting it, you would work different outcomes?
I believe that the Constitution applies differently in that situation. Because here we have a constitutional violation. The whole problem here is that the Tennessee Constitution recognizes a stronger due process protection. And that due process protection is the source of the duty to preserve potentially exculpatory evidence. And the trial court found in that finding of due diligence evidence that this evidence was potentially exculpatory. Just like in Marion, where the Tennessee Supreme Court approved dismissal, they said it could have been favorable to the state, but it was potentially exculpatory. And therefore, the duty arises not from Rule 16, but from Article 1, Section 8 of the Tennessee Constitution of all the lands. So that supersedes anything Rule 16 has to say about this. And just briefly, Your Honors, on a couple of points, as my time winds down, my friend made a point about the substitute evidence in this case that I'd like to just briefly talk about. First of all, as I mentioned earlier, all of the substitute evidence pertaining to the 911 call was incomplete and conveniently more favorable to the state. That's the problem we saw in State versus Liberty Park, and we see it here again as well. And as far as the other evidence, statements to the police and so forth, it was inconclusive and far from overwhelming as to his mental state. It was overwhelming that the killing took place, and we can see that. But when it comes to his mental state, it was not overwhelming. It was inclusive. For that reason, we asked that this court reverse the judgment of the trial court, dismiss the accused of trial.
All right, thank you. This case was really well briefed, and I appreciate your good arguments and your patience with all of our questions. We're going to be in recess, and Judge Griffiths, you want to let them know how the
Sure, yeah.
question and answer will go?
I think this is a wonderful opportunity, one that candidly doesn't happen if we're in an actual court setting. So you as students have the opportunity to talk with both of these lawyers. They're both excellent, outstanding advocates. Pretty impressive, actually, on both sides. It was a great argument. You have an opportunity to ask them questions, either about the case, you can ask them questions about
Check, 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 check. Mike, Mike. Check, check. Down? Okay. Check, 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 check. Mike. Check, 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 check. Up. Down. Mike, 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 Mike. Check, 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 check. Mike, Mike. Okay, should be good there. Not picking up anything at all. Check, 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 check. Check, 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 check. Mike, Mike. Check, 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 check. Mike, okay. Check, 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 Mike, Mike, check, check, Mike, Mike. Check, 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 Mike, Mike. Yeah, that's better. this more center with Bobby. Check 1 2. Check 1 2.
Look over at me, and I'll tell you if we're on the tape or not. That way, yeah. Okay. Okay. Well, sorry I didn't communicate with you.
We had some other stuff.
Check 1 2 3. Check. It's on. Check. 1 2 3 4 5 6 7 8 9 10 11 12 13 14. One, two, three. Does dropping the bass out of it help any? Did you drop the bass out of it? Does it help any? He'll be right here. 1 2 3 4 5 6 7 8 9 10 11 12 13 14 15 16 17 18 19 20 21 22 23. Huh? You good? I can hear me. Yeah. Okay. One, two, we're good. One, two, three. One, woo. 1 2 3 4 5. Good.
Okay, everyone, if you're new to the proceedings, just want to remind you, this is a courtroom, so if you will please turn off your cell phones, or at least silence your cell phones so we don't have them ringing, and we're about to get started, restarted. Thank you.
welcome back. I'm not sure if we have new groups of students in the audience, so I will just kind of briefly go over how we handle things. Each side has 20 minutes for argument, and if the appellant wants rebuttal time, please let us know on the front end. We've got the timer to take care of that. Anything else we need to address? All right, if you'll call the next case, please.
State of Tennessee versus Clarence and Forte.
Good morning, Your Honors. May it please the Court, Brennan Wingirter on behalf of the appellant, Mr. Clarence Porter. With the Court's permission, I'd reserve 4 minutes for rebuttal. Your Honors, we've all heard the phrases, wrong place, wrong time, guilty by association, you are the company you keep. Those phrases are not the law in Tennessee. In fact, Tennessee law is quite the opposite. A person's guilt in a criminal case cannot be based on their mere presence at the scene of a crime. A person's guilt cannot be based on their mere association with other people who commit crimes. And, at least now, in this case, it is still the law that a person's guilt cannot be based on the uncorroborated testimony of a charged co-defendant or accomplice. But those 3 things, presence, association, and uncorroborated accomplice testimony, are all that the state has against Mr. Clarence Porter in this case. Without any corroborating evidence of the accomplice's testimony, and without any independent evidence establishing Mr. Porter's commission or intent to commit any of the charged crimes, the theft, the robbery, or the ultimate murder in this case, means that Mr. Porter is serving a lifetime in prison for crimes that he did not commit. Now, we know that Mr. Blake Orr is the person who pulled the trigger and shot and killed Mr. James Johnson. We know that Mr. Orr was there that day because he got a phone call from a woman named Queena Brown. Ms. Brown and Mr. Orr both pleaded guilty to their roles in the commission of these crimes, and they are serving time in prison. Mr. Porter, however, was there, literally along for the ride. And I think what is probably the best, I'm happy to answer any questions that the court has about any of the issues raised in our briefs, but I would like today to focus on that accomplice corroboration rule and the lack of sufficient evidence of Mr. Porter's intent or participation in any of the charged offenses. Of course, I'm also happy to talk about the conspiracy and hearsay issue and the prosecutorial misconduct, if the court would like. And I would, just for the benefit of the audience, I would note that Ms. Redding, who's here on behalf of the state, was not the prosecutor at trial and did not write the brief for this appeal. And so anything I say about the state either misrepresenting or misconstruing the record is certainly not personal.
So, counsel, before you start, let me make sure that I understand where the argument is going today. Would you concede that if Ms. Brown's testimony were corroborated, that there's sufficient evidence then of intent against Mr. Porter?
No, Your Honor.
Okay. So her testimony alone is not sufficient to sustain the conviction if it were corroborated?
Correct.
All right. How is that? Can you help me, please?
Yes. So I think it's important to remember the way that the legal standard works in this case. So to start first with the corroboration rule, the trial court had to rule, and did rule, at the mid-trial motion for judgment of acquittal, whether there was sufficient corroboration of Ms. Brown's testimony for the crimes to even go to the jury for consideration. So at that point, it's sort of a preliminary quasi-legal, quasi-factual determination by the trial court about whether there was sufficient corroboration. It then went to the jury. So the corroboration does not have to prove, or the corroborative evidence does not have to independently establish guilt beyond a reasonable doubt.
Sure, and it only has to be slight for those purposes, but taking that aside, let's assume that it's corroborated, let's assume it's credited by the jury, and if we view her testimony in the light most favorable to the state to sustain the conviction, as we would have to as the law requires us in this court, her testimony alone, you're saying, would not be enough to support a finding of each element beyond a reasonable doubt?
That's correct.
Which elements would be missing?
So if I may take one liberty to first correct just one thing about the legal standard. Your Honor said, however slight. And I do think that the corroboration rule for accomplice corroboration is higher than that.
I want to get to corroboration. I'm just saying, let's take that off the table right now, just so I know where the argument is headed.
Yes, Your Honor.
Let's assume it's corroborated. I know we'll talk about that in a
Okay.
minute. Assume it's corroborated, assume it's fully credited by the jury, and we have to give that deference. Which elements does her testimony not satisfy?
Okay, so the crimes were theft, robbery, and ultimately a murder. Because it is undisputed that Mr. Porter did not actually commit any of those, the state's theory was based on criminal responsibility. So for criminal responsibility theory in this case, for the theft, the state had to prove that Mr. Porter had the shared intent with Mr. Orr and Ms. Brown to take something from Mr. Johnson. That's number one for the underlying predicate offenses. The state has to first prove
Or
those.
to benefit from somebody else's robbery?
Correct, Your Honor,
Okay,
yes. So if those are proven, then to get to the felony murder, the state still has to prove that the killing, the death, was connected to the predicate charged offenses. So we really have two prongs of attack against the state's case there. Number one, even if you accredit Ms. Brown's testimony, and even if there's sufficient corroboration, there's no proof that Mr. Porter intended to participate in these crimes. So for the theft, for example, the underlying predicate, I'll talk about the theft and the robbery kind of together because it's both about a taking. The state's only evidence, other than Ms. Brown's testimony, and even if you take Ms. Brown's testimony, the only evidence against Mr. Porter was he was there. Initially, Ms. Brown said Mr. Porter never got out of the car. She later changes her story and says, I don't know when he was in the house, but at some point he was in the house with his hands in his pockets. He didn't touch anything. He didn't take anything.
Didn't he supply, though, the weapon that Mr. Orr used?
Your Honor,
according to her?
That was not, according to her testimony, after they returned back to Chattanooga, Mr. Orr handed the firearm to Mr. Porter and said, essentially, here you go, get rid of this. That, however, was not proven beyond a reasonable doubt, number one. It wasn't even established by anything other than her saying that that happened.
Okay, so if we fully accredit her testimony that that happened, that would support, would it not, the aggravated robbery, right? Because he's providing the weapon that's used in the theft.
So, but I don't think that we can do that, Your Honor, because even if you accredit her testimony, she's still an accomplice. So you don't get past the corroboration.
Okay, all right. We keep going back and around. I think my questions right now are assuming that it is corroborated. I know we're talking about that, and the court's certainly not there yet. I'm just trying to figure out, on her testimony alone, if we credit everything, I think we would have to credit that Mr. Porter gave the weapon initially to Mr. Orr that was used in the homicide, right?
I don't think the court has to conclude that. Number one, the trial court didn't conclude that.
Okay.
Number two, that never went to the jury to decide.
Okay.
So this court would be making a factual finding that was never made at the trial court level if the court decided to do that.
Okay.
And I don't think this court can do that. Another point to that is, again, the firearm was never recovered. And there's nothing other than Ms. Brown saying, or handed it to Porter, Porter took it inside and got rid of it. That's it. That's not enough to prove that, one, he provided it, and two, that he knew from the outset of this round trip that he went on with his friend that any of this was going to happen. And I think that's actually bolstered by Ms. Brown's testimony, if we are going to credit everything she said. At one point, she
And
testified.
we have to, right, if it's corroborated?
If it is corroborated,
Okay,
Your
sure.
Honor. And she, at one point, she said that Mr. Orr, right before he shot Mr. Johnson, said, if you ever touch her again, I'll kill you. That is wholly unrelated to the state's theory of this was some attempted theft, robbery, they were there to take collateral. If you really look at the context of this case, Mr. Orr has some sort of, I don't know if it's like a hero complex or something, where he is there thinking he's trying to avenge Ms. Brown, who was living with Mr. Johnson at the time. That had nothing to do with this allegation of we're going to take collateral that ultimately ended up with no TVs being taken, which were the alleged collateral under the state's theory. The only thing supposedly taken was Mr. Johnson's cell phone, which by Ms. Brown's testimony, they then threw out the window. So no, there is no real collateral here anyway regarding the theft or the robbery.
And is it clear who took the cell phone or
No.
any of the information about the cell phone? Can you give me some clarity on that, on what is actually in the record?
Yes, Your Honor, because even I actually got confused at one point, and I went back and double-checked to make sure that I was stating this accurately. I believe this is accurate for the court. Ms. Brown never said that Mr. Porter took the cell phone. And in fact, Ms. Brown testified, actually even before trial, before her trial testimony, in her pretrial statements to police and at trial, she repeatedly said, I took the phone. I had the phone, I had the phone, I had the phone. She took Mr. Johnson's phone because she wanted to be able to get her clothes back. So she's like, hey, I've got your phone, give me my clothes back, and then, I'll get out of here. She had the phone the whole time. She then at trial, again, not only inconsistent with her pretrial statements, but contradictory to her own trial testimony, she then later says, well, somehow it ended up in the car with us. She then says, a little bit later, that Mr. Orr gave the phone to Mr. Porter, who threw it out the window. So at best, Ms. Brown's testimony regarding Mr. Porter's involvement with the phone was he tossed it out the window over the Chickamauga Dam. Again, that's not sufficiently corroborated, but even if you take that as true, that does nothing to prove his intent with a theft or a robbery. At best, as we discussed in the brief, it's an accomplice after the fact, which he wasn't charged with. So that's it for the phone. And if anything, Ms. Brown is admitting that she was the one who took it all along. And it was from the trial testimony, that portion is in volume 9, I think it's pages like 380 to 384, where she says multiple times that she had the phone. Then it was the trial judge, who I think got this wrong on the facts, at the mid-trial motion for judgment of acquittal said, well, it's either that Ms. Brown had the phone the whole time, or either Mr. Orr or Mr. Porter took it and got it into the car. That is pure speculation. Everything about what Mr. Porter did or didn't do is purely speculative in this case. The trial court saying either Porter or Orr took the phone is not based on any testimony in the record, not even Ms. Brown's. Ms. Brown's testimony was she had the phone and then somehow it ended up in the car. So if we accredit one of her versions, that she left it in the house and somehow it ended up in the car, so someone else had to get it, you then have more contradictions, which is she first said Mr. Porter never got out of the car. He was never in the house. She then says, okay, he was in the house, but his hands were in his pockets. He didn't touch anything. He didn't take anything. So then to extrapolate, as the trial court did, that maybe Mr. Porter took the phone is not based on anything that Ms. Brown said or any other proof in the record. It is pure speculation, and as this court well knows, we cannot speculate people into a lifetime in prison. There's just nothing else there. If the court would like to go back to more of the corroboration.
Let's go back to the corroboration. Your friend on the other side talks about the different types of corroborating evidence, and one of the things that is raised by the state is the text messages that are between Mr. Orr and Mr. Porter. Can you speak to those, please?
Yes, Your Honor, of course. So the first text message that the state points to as corroborative evidence is Mr. Orr's text message to Mr. Porter, should I do her? Now, it's unclear what that means, but even assuming, as the state has posited, that means Mr. Orr was seeking Mr. Porter's approval to kill Ms. Brown as a witness to what had just happened. Nothing about that proves Mr. Porter's intent to engage in any of those crimes for a couple of reasons. Number one, Mr. Porter never responded to that text, at least not in writing. Number two, Ms. Brown, as far as I know, is still alive. And so if Mr. Orr were looking for approval to kill Ms. Brown, that didn't happen, and Mr. Porter certainly did not have some sort of permission to give as the alleged ringleader, as the state has claimed, which is, again, not based on anything in the record. The other text message that the state relies upon is Mr. Porter's text message to Mr. Orr sometime after these events that he was totally violated for real, which was interpreted to mean, I believe he was on either parole or probation at the time, so he was telling his friend, hey, man, what you did got me violated. Now, the state says that the totally violated text somehow shows Mr. Porter's conscious guilt in the crimes that were just committed. So I'll say a couple of things against that. Number one, if someone has just committed a theft, a robbery, and a murder, I would think a parole violation, a probation violation, is the last thing that they would be worried about. So that text proves nothing about his guilt of the crimes that had been committed. And number two, when you read that text in context, the response from Mr. Orr, LOL, I'm taking care of stuff, I got you, is Mr. Orr's acceptance of responsibility, which again, he pled guilty. I mean, he admitted that he's the one who pulled the trigger. Admitted he's the one who did this. And so Mr. Orr is saying, don't worry about it, man. I got you, I got your back. Because you didn't do anything. And so that's it in terms of text messages. The text from Mr. Orr that was not responded to, and the text from Mr. Porter about, hey man, just being here with you when you've just done this, that I had no idea was going to happen, probably puts me at risk of violating my probation or parole. That's it. It does nothing to establish, even if you assume there's corroboration, it does nothing to establish Mr. Porter's intent or shared intent or criminal responsibility for what had just happened. And those are the only text messages that the state points to. There were some text messages from Ms. Brown to other people, but not to Mr. Porter. They did not even know each other.
Those text messages, though, did go to Mr. Orr, right? And she was seeking help in a robbery, right? Or a theft, taking back maybe her own property?
One of her text messages to Mr. Orr indicated, like, hey, if you come get me, you can take whatever you want from his house. That went to Mr. Orr. Nothing was taken from the house by her own testimony.
Okay.
But she did send out like a number of other text messages earlier, and that's where I felt like the state's brief was a little confusing, or maybe conflating that, trying to say that those text messages she sent out looking for help, it was implied that some of those maybe went to Mr. Orr, or somehow he was responsible for receiving them or knowing about it, but the record does not support that, does it?
Correct, and that's part of our prosecutorial misconduct argument as well, where the prosecutor references Ms. Brown's text to some unknown third party about sending shooters and being a lot different from what she sent to Mr. Orr. And in closing argument, the prosecutor basically said, she sends a text, send shooters, and then Porter and Orr show up. That is a complete improper conflation of those text messages, who they went to, these unknown third parties that weren't even a part of this case. It has absolutely nothing to do with Mr. Porter's intent, even assuming it's corroboration in some way. I see my time is up. Unless there are further questions, I'll reserve for rebuttal.
Thank you.
Thank you.
General?
May it please the court, Catherine Redding on behalf of the state. The evidence is sufficient to sustain the defendant's convictions. Viewed in the light most favorable to the state, which is a standard of review when we're dealing with a sufficiency issue, there is sufficient evidence for a reasonable jury to find that the state corroborated Ms. Brown's testimony implicating the defendant in the conviction offenses, and that the state showed that he did intend to commit the theft or robbery that underlie the felony murder convictions. And it's important to keep in mind that this case, the defendant was charged with felony murder, and he was charged with the especially aggravated robbery and theft under a theory of criminal responsibility. So that's the background and where we enter, kind of the lens with which we use to look at the proof. And if we look at the corroboration evidence, what we have is Ms. Brown's text history, which shows that she did spend the morning looking for somebody to help her rob the victim. Yes, most of these texts were not to Mr. Orr.
Well, in fact, none of those asking for that kind of help went directly to Mr. Orr, did they?
Well, Mr. Porter?
Or,
Mr. Porter did not receive any
Okay.
text.
Right.
Mr. Orr did not receive any of the initial texts. What the record shows is she sent all of these text messages, so we have an idea of what Ms. Brown's
right, I think,
situation
I
was.
get that. We can see
Yes.
from her text messages what she was looking for, but what we're really looking at is what the intent of Mr. Porter and Mr. Orr were.
And I think we have to go further down the phone records and what the texts show. So we have all of these texts from Ms. Brown, and then we have a lengthy phone call between Ms. Brown and Mr. Orr.
But we don't know what that phone call was about.
We do not, but we do have a text message that follows that conversation that says, when Mr. Orr announces that they are 15 minutes out, she says, okay, when you get here, the TV's to the left. That text message doesn't make any sense unless a reasonable jury could infer from those text messages that the phone conversations, which obviously were not recorded, we don't know what they say, but that there was a discussion of the robbery, because otherwise you have a text message from Ms. Brown to Mr. Orr talking about the location of a television out of nowhere. So a jury, viewed in the light most favorable to state, a jury could reasonably conclude from that text message and from what we know of Ms. Brown's morning and what she was planning, that the conversations that she had with these other people were repeated in some fashion to Mr. Orr, such that texting him, here's the location of a television, here's a photo of the television, would make sense to Mr. Orr. And if we go back to kind of the earlier conversations, what we have is Mr. Orr's phone records, going back to the corroboration, Mr. Orr's phone records showing that immediately after he gets off the phone with Ms. Brown, he calls the defendant. And in fact, he calls him twice. Then we have Ms. Brown texting Mr. Orr to ask how long it's going to take him to get there. We have the phone records before Mr. Orr actually calls Ms. Brown back. He talks to the defendant 4 more times.
But again, we don't know what those phone conversations were.
We don't. But viewed in the light most favorable to the state, it is reasonable, a reasonable jury could conclude that there were conversations between Mr. Orr and the defendant. And given the conversations that we have with the text message about where the location of the television and the photograph of the television, a reasonable jury viewing this evidence in the light most favorable to the state could conclude that there was more than just a conversation about, hey, what time are you going to get me? Can you give me a ride? My recollection of the record is that they showed up in Mr. Orr's vehicle, or I believe his mother's vehicle. So it wasn't a matter of, Mr. Porter, can you give me a ride? Mr. Porter, can you help me? There was more to that. And it's important. Again, viewed in the light most favorable to the state, a reasonable jury could conclude that there was an agreement.
Well, they would conclude that this conversation happened between Mr. Orr, but they would also have to infer that Mr. Porter was privy to that conversation and knew the contents of what they were talking about.
Yes, they would. And so I think kind of broad picture, knowing what Ms. Brown had in mind that morning, knowing that she contacted Mr. Orr.
But is that not just too big of a leap to go from what we know she was, I think that's the clearest thing we have in the record, is what she was looking for help with.
Yes.
But then to say that without any direct evidence in the record that she, or really much circumstantial evidence other than speculative, that she communicated that to Mr. Orr, who communicated that to Mr. Porter, who agreed to go along with it. I mean, I'm just struggling with the actual evidence in the record, and I know you've got what you've got in the record, but
I'm not sure I'm articulating this very clearly, but I think kind of back to your point, Judge Cranolds, the first issue is whether a reasonable jury could conclude that Ms. Brown's testimony was corroborated. And so then do we get to the point where we have Ms. Brown's testimony and then we have the additional testimony? And it's the state's position that we can corroborate her testimony because all that's required is just slight corroboration. And you don't have to corroborate every single thing that she says. And the text messages, the phone records, the cell location data all track what she is saying, and that it's establishing what her mindset was in the morning. She was looking for help. It's showing Mr. Orr had a phone conversation with her. It's showing all of these very extensive communications between Mr. Orr and Mr. Porter. It's showing the two of them getting in the vehicle and going to Ms. Brown's location.
General, where does Mr. Orr get the weapon from? What does the record say?
According to Ms. Brown's testimony, which of course has to be accredited, and we can infer that it was given the verdict, her testimony was that at the end, when they got back to Chattanooga, Mr. Orr handed Mr. Porter the weapon and said, here's your gun back.
As if to return the weapon that he had received from Mr. Porter?
Yes.
Okay. So if we're drawing those inferences in favor of the jury's verdict here, your friend on the other side, I think this is fair to say, relies heavily on the jury's acquittal of Mr. Porter being a felon in possession of a weapon.
Yes.
Is the state's response that's just an inconsistent verdict under Davis and that's what we have, or is there more to it?
I don't know that it's an inconsistent verdict, but I do think that it had its effect on the evidence underlying the convictions for counts 1 through 4 is limited. In count 5 is his possession of the weapon. And all there is Ms. Brown's testimony. There's nothing else, so it was appropriate. Okay. But here, when we're talking about felony murder and we're talking about criminal responsibility, we have more. We don't have just Ms. Brown's testimony because we have the text messages, we have the cell phone location data, we have the conversation between Mr. Orr and the defendant, and it's the state's position that viewed in the light most favorable to the state, a reasonable jury could infer or could construe the defendant's text message about totally violated to mean that the defendant was viewed in the light most favorable to the state. It's not about his probation or his parole being violated. It's about, it's an acknowledgement of his role or his participation in these offenses. And as to the text where Mr. Orr asked if he should kill Miss Brown, the fact that the defendant didn't respond is, frankly,
Well, he didn't say, should I kill her? He says, should I do her?
Well, viewed in the light most favorable to the state, a reasonable jury could infer that when he said do her, he meant kill her, given that it was sent just after the text message, as it wasn't like Mr. Orr later when he was at the hotel with Miss Brown said, should I do her? He was asking this in the immediate aftermath of a murder. He's asking Mr. Porter, should I do her? A reasonable jury viewing this in the light most favorable to the state could conclude that he meant, should I kill Miss Brown? And the fact that he is asking Mr. Porter doesn't necessarily, I tend to say that doesn't necessarily mean that the state is arguing that Mr. Porter is the ringleader, but it means that Mr. Porter is not just a bystander. He's not along for the ride. He is criminally responsible for this, and that is.
So let me push back on that gently. Let's assume the jury does not credit Ms. Brown with respect to the felon in possession count. As you said, it's possible the jury didn't credit her in that regard. If Mr. Porter did not provide the weapon to Mr. Orr, how is he criminally responsible for anything? I hear your friend on the other side say all you have at that point then is presence. You don't have encouragement. You don't have evidence of Mr. Porter taking anything, actually participating in a theft. If he is not providing the weapon to Mr. Orr, where is his responsibility at all then?
I'd first like to clarify, the jury did not acquit Mr. Porter of the possession. That was the trial court dismissed.
Trial court, yeah, yes, okay.
So the jury,
fair enough.
We don't know what the jury thought about that.
Fair enough, but let's assume that
Sure.
the facts are, just for sake of the hypothetical, that Mr. Porter did not provide the weapon to Mr. Orr. Where is his responsibility then for theft, for felony murder? Where is his responsibility then?
Well, this case is based on circumstantial evidence.
It is, and that's what I'm trying to get to.
Sure.
It seems to me the weapon is really important.
I think
it's really important, and so if we remove that critical fact, what else do we have that would support the convictions?
I would agree that the weapon is important, but I don't think that it's the end of the story. I think that Ms. Brown's testimony, she acknowledged at trial that she's not sure how the defendant got into the residence, but she said when she went into the residence that she walked in and she saw the victim's body in front of her. She saw Mr. Orr to the left, and then she saw the defendant to the right. She said that his hands were in his pocket. She said she didn't see him take anything. That does not mean that she wasn't there when the shooting happened.
True, but there's no proof that he took anything, right? Is there any proof that Mr. Porter took anything?
There is proof that items were taken, the phone was taken from the residence, but no, there's no proof that the defendant is the one who took it rather than Mr. Orr, but again, criminal responsibility.
Is there any evidence that anything other than the cell phone was taken? The cell phone is fine. I mean, I understand the theory on that, and that would be perfectly sufficient perhaps. Is there any other item that is taken from the victim other than the cell phone?
My recollection is that the state did argue at trial that cash and pills were taken. Mr. Johnson was providing Ms. Brown with Roxy's to sell, and it was Ms. Brown's testimony, and that's backed up by text messages, and it was Ms. Brown's testimony that she had acquired about $500, and the testimony from the state's witnesses is that no cash and no pills were found at the residence, even though we have testimony from Ms. Brown that there should have been cash and there should have been pills. So we have that, but we also have a statement from the defendant that Ms. Brown testified to at trial. She said that when she went into the residence, the defendant was standing by the dresser. The dresser drawers were out. It looked like the house had been tossed. And that the defendant told her that she knew there was something of value in the house, she better start searching. So I think that given circumstantial evidence, but given if we accredit Ms. Brown's testimony, we find that it was sufficiently corroborated as the jury did. We conclude from the number of phone calls between Mr. Orr and Mr. Porter. We can conclude from even without the gun, from Mr. Porter's own statement and from Mr. Porter's presence in the house, that in the immediate aftermath of the victim being beaten and shot in the chest, that the defendant was criminally responsible, that he did, he was more than just merely present. And I think he also...
So what I'm hearing, though, is that he communicated with Mr. Porter. We don't know the substance of it, but maybe we can make some inferences that Mr. Porter is going to do something. We have his presence at the house. What are the statements that Mr. Porter is making at the house that would show that he's either facilitating or actively engaged in or benefiting from or helping to further the theft? What are those statements?
Ms. Brown testified that when she went into the residence, the defendant said if she knew there was something of value in the house, she better start searching.
Okay.
So given that, and also I'd point this court to the Eric Boyd case, which was criminal responsibility.
Sure.
I don't think that it rises quite to the level there, but in that case, this court discussed presence and companionship of an accused before and after an offense being circumstances from which participation in a crime can be inferred.
Not alone sufficient.
Correct.
Right? But what I'm hearing you say is that it's not alone, that we have the statements of the defendant and text messages, phone calls between Mr. Porter and Mr. Orr.
And if we look at Mr. Porter's actions after the shooting, I mean, we have the text message, totally violated, and a reasonable jury could construe that to be a statement about conceding to his role. And then we also have the fact that Mr. Orr stopped the vehicle multiple times on the way back to Chattanooga. The defendant never got out of the car, never said anything, never tried to part ways with Mr. Orr. The phone records show Mr. Porter was sitting in the car watching YouTube on the way back to Chattanooga. I mean, these are not, we have companionship, we have presence, we have statements, we have enough evidence from which, when viewed in the light most favorable to the state, a reasonable jury could infer that there was more to this arrangement, especially leaving Chattanooga. There was more to it than just simply do you want to come along for a ride? I mean, I believe it's 11 phone calls in the course of an hour, and it's every time Mr. Brown and Ms. Orr speak, immediately the defendant gets a call, multiple calls, and it's just follow up. And so if you look at all of it together, under the standard of review that the state as the prevailing party is entitled to for reviews of sufficiency on appeal, a reasonable jury could find that the defendant was guilty of the conviction offenses. Unless this court has any further questions, the state asks this court to affirm the judgments of the trial court. Thank you.
A few points on rebuttal, Your Honors. First, just factually, the quote from Ms. Brown was, he said, if I knew there was anything here for real, for sure, I'd be searching. That is entirely unclear as to whether that meant Ms. Brown should be searching, Mr. Porter would be searching. What is clear is that no one was searching. I would be searching was the testimony, not, you should be searching or you are searching. And that's in volume 9, 384 to 386, and it's quoted in our brief regarding what Ms. Brown said about when Mr. Porter was supposedly inside the house. But I want to go back to the legal standard more importantly. The state does not get to use the light most favorable to the state or reasonable inferences made by the jury unless they first clear the corroboration hurdle. Corroboration is not a jury question. It was for the trial court to decide first. And that is where the error is. So a few things on the corroboration rule. It is not slight corroboration. We have that standard in other corroboration rules in the law, not the accomplice corroboration rule. The accomplice corroboration rule requires that independent of the accomplice's testimony, there must be proof that fairly and legitimately tends to connect the defendant with the commission of the charged offense. That is more than slight corroboration of Ms. Brown's testimony. And there's a reason why we require that. She changed her story multiple times before and during trial. We do not, this court and the parties on appeal, we do not have to accredit her testimony with regard to the corroboration requirement. I think the state does get that more favorable standard if it goes to the jury. But if this court concludes that there was not sufficient corroboration, we're not taking things in a light most favorable to the verdict at that point. We're looking at this under the corroboration standard. Regarding what the state had for corroboration, there was nothing, no more evidence, no more alleged corroboration of the theft, the robbery, the murder, than there was of the possession of the firearm. And I appreciate my friend bringing up the fact that that never went to the jury. The trial court did find no corroboration of Ms. Brown's claims about that gun. The claims by Ms. Brown about the cell phone being tossed out the window, there's no more corroboration of that, or the state has not put forth any more corroboration of that than they did of the gun. It's almost the same testimony from Ms. Brown. Mr. Porter disposed of that item. He disposed of the gun. He disposed of the phone. If there's not corroboration regarding the gun, there cannot be corroboration regarding the phone, period. And we're not talking about inconsistent verdicts because we are talking about the trial court's decision on the corroboration legal standard before this goes to the jury, before we look at things in a light most favorable to the state, before we accredit Ms. Brown's testimony. And that's exactly why the accomplice corroboration rule still applies in this case. Unless there are further questions, I will just sum up by saying, as this court has pointed out, there's plenty of evidence about Ms. Brown's intent. There's plenty about Mr. Orr's intent. The state has nothing about Mr. Porter's intent, and nothing that it has put forth, corroborative or aside from the corroboration, independently regarding Mr. Porter's intent. Nothing is sufficient to uphold these convictions. We're asking this court to reverse and enter judgments of acquittal, or for the alternative reasons in our brief to remand for a new trial because of the hearsay and prosecutorial misconduct during closing. Thank you, Your Honors.
Thank you. Thank you again to both the attorneys for your good arguments and briefs, and just appreciate y'all making the effort too to be here in Chattanooga, a little different venue. We're all out of our usual environment, so thank you all for making the effort and being here for the students. So we're going to be in recess, and again, the students will have the opportunity to ask questions of the lawyers, and then we're going to take a lunch break, and we'll be back for our last session at 1 o'clock.
Yeah, I think that's right. As students that are here, take advantage of this opportunity. This is not something you would have an opportunity to do if you attended court. So if you were otherwise hearing this case in Knoxville, which is where we'd be hearing it otherwise, you wouldn't have the opportunity to ask the lawyers questions either about the case, about what they do for a living, about how they got to law school, why they're interested, why they do this work in particular. These are outstanding advocates. Take advantage of that opportunity as we go. So, yeah, thank you all.
All rise.
right, welcome back, everyone. We are back in session for our final argument of the day. And again, I just want to express my gratitude to all the folks at UTC here and the lawyers who have made the effort to be here today. And Judge Tom Greenholz is really the one who put all this together, so I wanted to give him credit. It was those of you who just sat in on our luncheon, when he tells you he's kind of obsessed with all this, he is. It was about a year ago, wasn't it, Judge Hickson? He came up with this idea, and he's worked on it diligently since and pulled it off.
With the good help of about
with the help
100,000
of
people.
his staff and the
Yeah.
our court clerk and offices. So anyway, with that, we'll call the last case.
Byron Hartshaw versus State of Tennessee.
And before your time, again, we've got students here, and since this is a post-conviction, maybe give a little bit of background on what post-conviction is to the extent that that doesn't mess up your arguments.
I can do that.
Thank you.
Thank you. Good afternoon, Your Honors. May it please the court. My name is Autumn Bowling. I'm here for the appellant, Byron Hartshaw. I'd like to reserve 5 minutes of my time for rebuttal. This case arises out of a post-conviction proceeding in which Mr. Hartshaw has already exercised his direct appeal to this court, has now gone back to the trial court in its function as a post-conviction court, and has alleged instances of ineffective assistance of counsel by his attorney, who I'll refer to as trial counsel, throughout this argument. And so where I want to start is that our entire profession is based on communication. Whether it's orally in court like we're here today, or we're writing something down and filing it, we're exchanging emails, text messages, our entire profession boils down to communication. And if we are not doing it effectively, if we are not responding, we are failing. Now I'd like to focus on, out of my brief, this would be issues presented numbers 1 and 3 is what I'd like to focus on. And the broad facts of this case are that the petitioner, Mr. Hartshaw, and his co-defendant were charged in relevant part with counts 1 through 2 of aggravated robbery with a deadly weapon, and counts 3 through 4 of aggravated robbery with an article fashioned to allow the victim to reasonably believe it was a deadly weapon. And so when the trial counsel reviewed the case, actually his co-defendant's counsel, Mr. Gindy, realized there were 2 items mentioned that could be alleged to be either the article fashioned or the actual deadly weapon. And that was both a gun and a hammer. Mr. Gindy filed a bill of particulars that Mr. Hartshaw's trial counsel joined in on. And so there was a hearing, and what this bill of particulars was for was to identify and ask the state to particularize and memorialize whether or not this hammer was supposed to be the deadly weapon alleged in counts 1 through 4, or if it was the hammer as well. Now, when they get to the trial court during this hearing, the trial court asked the parties to go ahead and discuss this, and the state gets up and puts its position about the hammer on the record. The trial court then, I'll say, mirrors that position back. And without objection, the parties are satisfied. And what the trial court says at that point is very important, and I would like to get to that in just a moment. But there's no real, I'm going to say there's no official ruling from the bench. There's no real resolution as to what this happened with this bill of particulars, whether it was actually dismissed, whether it was considered resolved, granted.
Was there even an order in the file or anything to that effect in the record that we'll find?
There was no order, Your Honor. This was all done orally. And so they gave their position, and basically what the trial court had said was, well, I think that solves it. Okay, everybody's happy, we'll move on.
And
go
what
on to our
was the
next motion.
position? What was actually said in court? We do have that. I assume we have a
Yes.
transcript.
And so the state's position was that, one, these were prosecutors who did not handle the court in sessions, so they were not actively involved in the case until it got here to this point in criminal court. And so the prosecutor's position was that it's not going to be the hammer. Just boiling it down as simple as possible, it's not going to be the hammer. It's about this firearm. It's about this gun that was alleged to have been seen. And this hammer is They didn't say it was just a stolen item, but that's originally how
Well,
it was written.
it's a little different than that, though, counsel, right? Because didn't the state say, I haven't reviewed the preliminary hearing, I need to go back and take a look at the preliminary hearing. As I understand it now, the deadly weapon is the firearm. But the state didn't come out and say before the judge, hey, the firearm is the only deadly weapon, right? They left the door open to come back, isn't that right?
I would not agree with that, Your
Okay.
Honor.
How so?
This was that they got up and said, we were not the prosecutors who handled this. I actually think they did say we listened to the audio. I think, though, that they had not, either it hadn't been recently or something else had happened. I can't get into their minds, but they got on the record, made their position, and what I think is very important here is that the trial court said their position back to them. And I want to read what that quote is, because the state did not object to this. And so the trial court resolves it as, the hammer is not the deadly weapon that's being referred to in the indictment. It is, in fact, what appears to be or is alleged to be a handgun. So that appears to be means that he is referring and saying it's not the hammer that's the article that's fashioned. And that's really where this gets to, is counts 3 and 4. And
Was
so
the
when
bill of particulars, did it cover all 4 counts?
It did, and so there's actually, this is somewhat in the record and somewhat not, but there was an original indictment where the hammer is actually, everything's kind of listed out in the indictment. And then there was a bill of particulars by, again, Mr. Gindy, the co-defendant's counsel. And then there was a superseding indictment that came out. And I checked with Mr. Gindy as well, because this motion and bill of particulars is not in the record, and it was not in Mr. Emery's direct appeal record, from what he told me. And so if I need to supplement the record with that, I can, but what I can tell this court as an officer of the court is that in reviewing the motion for bill of particulars that Mr. Gindy sent me, it did ask for counts 1 through 4.
But that's not in the record.
It's not in the record that I have been able to find, and he did not believe it was in Mr. Emery's direct appellate record as well.
So, counsel, let's assume that the state, and I'm not sure this is the case, but let's just assume that the state thought that it was entering into a stipulation at that point. Could the state have withdrawn the stipulation?
I do not think so.
I mean, it's irrevocably binding?
Pardon?
It's irrevocably binding? It's irrevocable? It's binding
No,
throughout?
and that actually, I think, gets to part of one of the issues that we've raised, which is that it wasn't in writing. So this all happens, and none of this is ever put in writing, not the court's order. All we have is a transcript. There's nothing, and that is part of our issue, is that trial counsel never even asked for this to be memorialized.
What else would have been memorialized outside of what was in the transcript?
Well, I would say that asking and saying, I don't think that this is resolved, Your Honor. I think what we need to do is have the state go ahead and memorialize their position in writing and respond to our motion for bill of particulars.
So if you're asking the trial court, though, to put down an order, what would the order say that is different from the transcript?
Well, I think it would have, I think it would say what's in the transcript. And again,
Okay.
I think that is
So we have the transcripts in writing.
We do, Your
So
Honor.
we know what happened there. So what would, I mean, one of the claims is that counsel should have gotten a written order separate from the transcript. What would the order have said that would have been different from the transcript?
I don't think it would have said anything different, but that's part of the problem, is that because it was never written down, when they get to the jury instructions later on down in the trial, nobody has a transcript just ready for this. And so what happens is that the trial court, I'm going to say, misremembers what exactly its ruling was or how specific it was, and that it agreed that the gun is in fact what appears to be or is alleged to be a handgun. It's not the hammer. They were encompassing, the trial court was encompassing counts 3 and 4 in its ruling in the transcript. But when we get to trial and we're talking about these jury instructions, we have nothing in writing at that point. If we're standing live in the courtroom at that time, nobody has a transcript.
So what's the deficiency of counsel? Is the deficiency of counsel not being fully prepared to have what is in writing there at trial?
No, the deficiency is not asking for it to be memorialized at all and accepting just this oral, I would say, allowing the trial court to just say it's solved.
Even though you can see the order would not have said anything different from the transcript.
Right, because when we get down the road, we don't have that in front of us. And what happens is that the trial court does in fact give a jury instruction. And this is, I think this is very important. And when I argued this, I actually put it on a PowerPoint to the trial court to emphasize what the trial court said at that point. When it granted the jury instruction on counts 1 and 2, it said, this is not the law, this is not the right decision, but I now have to protect your clients from ineffective assistance of counsel. And I think that's very powerful and very telling. And what the problem is that because there was nothing in writing, and we are all relying on our memories, and the state's getting up and saying, we had already withdrawn that, and that's the only thing that's really in writing, is their withdrawal on the email. And what happens is now the trial court thinks, well, I only have to fix counts 1 and 2, I don't have to fix counts 3 and 4, because the only thing that they asserted was that it was for counts 1 and 2. It's just the gun on counts 1 and 2. They didn't say anything about 3 and 4. But when we go back and look at the transcript, what the trial court said, and again, the state did not object to in what the trial court was rephrasing or paraphrasing as, it is in fact what is or appears to be or is alleged to be a handgun. There's nothing about the hammer. They are agreeing it is not the hammer in counts 1 through 4. And so when we get back to, we're standing here and we're talking about our jury instructions, and we're actively in the case, we do not have anything written down except for the state saying, I don't think that's the case. And then, which gets to the third issue of the brief, which is, or not the third issue, but...
Before we leave the first, can I ask a question, please?
Yes.
So the brief identifies the first issue as a failure to prepare a defense to the fact that the hammer could have been considered a deadly weapon or an article fashioned to believe that it could be. Is the entirety of that argument solely with respect to having the stipulation in writing, or are there other parts of the argument you're saying that counsel failed to do X, Y, and Z to anticipate or prepare a defense?
I think it is somewhat of a mixed bag, and I think what is complicated about this particular issue is that it becomes somewhat of a chain reaction. It all kind of starts out with, we went to this motion for bill of particulars hearing, we just let it, we didn't do anything else. We accepted what the court said, nothing was put in an answer, there's nothing official, there's nothing formal, we have nothing. Okay, maybe that's fine, but then we get the wrench, and the wrench is that the state very shortly after says, hang on a second, I'm going to take that back. And then trial counsel does nothing about it. And so when we talk about...
Is that accurate? Because trial counsel testified at the hearing that he received the email, received it from someone else. He researched it, which meant that he considered what was going on, and then based upon his research concluded that he didn't want to approach the court, that was kind of up to the state. So it's not like he didn't do anything about it, right? He received the email, he considered it, he researched the issue, and then made a judgment based upon his research.
In terms of, though, what was also revealed, though, at the post-conviction is that based on the fact that what he heard in court, that again, there was no order on whether it's, I don't know if it's a dismissed bill of particulars or what exactly it would be considered in our record. But what he was left with was that he said, I didn't prepare a defense for it, even though he knew there was
What would the
email.
defense have been? So on direct appeal, this court considered the issue and said that the hammer is a deadly weapon. As a matter of law, it is. It's either in its use or in the manner of its intended use is capable of causing death or serious bodily injury. It's a deadly weapon. What possibly could trial court have done outside of the stipulation issue to prepare a defense against the hammer not being a deadly weapon? What could trial counsel have done?
Well, for the first thing, I think, is that sometimes we just have these unchangeable facts. They're facts beyond change in our case. And so what would have happened if then, let's say he did go to the trial court and said, hang on, we got this email, I need to know what this means. And trial court says, well, I'm going to let them withdraw it then. They can use the hammer. Now he has to build his defense. And what I think the defense would be is, one, again, when you have a difficult task like that, you have to do more cross-examination. Again, getting into more of the credibility on that, more cross-examination.
On what point? On the hammer not being a deadly weapon?
Well, I think in terms of this, not being a deadly weapon, I think there is some argument to that about how it was used, how it was wielded. Because
I mean, this court concluded that it was.
Yes, Your Honor.
So already having that finding now in our global record that we know that the hammer is a deadly weapon, I mean, what other questions would he have asked? And is any of that presented at the post-conviction hearing?
Well, I think what he would have asked, or perhaps what I would have asked, going back again, I'm still arguing to a jury that has not decided anything yet, is that because there was originally the allegation seemed to be that the hammer was just a stolen item from the house. It may have been Mr. Emery's at some point, the co-defendant's. But that task would have then been, okay, I'm going to cross-examine my co-defendant because the co-defendant testified, which was another reason why Judge Sword, the trial court, decided to give a partial jury instruction on this. Because Mr. Emery got up and testified about the hammer. And if I was, I don't want to play, the Monday morning quarterback, but if I'm standing there, I'm going to have to talk to Mr. Emery and cross-examine him about, well, how are you using that? Did you pick it up? Where was Mr. Hartshaw when all of this happened?
Okay, so was any of that presented in the post-conviction hearing?
Pardon?
Was any of that presented in the post-conviction hearing?
No,
Typically in post-conviction law, when we say that counsel should have cross-examined a witness in greater detail, typically the law places the burden on the post-conviction petitioner to call that witness in the post-conviction hearing, ask the questions that should have been asked at trial, so that we have in the record what those answers would have been. Do we have that record here?
We do not, Your Honor. We did not call Mr. Emery to come down and did not call his lawyer.
Then that hurts us then to consider the theory that you're raising, does it not? Because it's not in the record that we have to consider?
I think it does make it more difficult, but I do not think it makes it impossible, because the issue isn't necessarily that he failed to raise a defense, and it does become an issue down the line, how things have been different. But when I look at it, failing to prepare a defense for it at all, just because we may think that it's not a great issue when we're standing there in trial, doesn't mean we can just let it go by. We still have to try and do something.
But in post-conviction, though, we have to show that it probably would have affected the outcome of the trial, the prejudice prong, right? And so even if we were to agree with you that somehow counsel didn't fully investigate the defense, it's important to know what that defense would have been so that we can evaluate that defense in the context of the proof to make a conclusion then that the outcome of the trial probably would have been different. So what would have changed here in the trial if counsel had done more investigation, as you say?
Well, I believe that trial counsel would have then actually addressed the issue instead of letting it go by.
How would counsel have addressed the issue such that we may have had a different conclusion, a lesser included offense, an acquittal? How would it have changed?
I think it would have gone to additional questions about the credibility of, one, the witnesses and the victim, as well as different questions to Mr. Emery, and all of this going back to, they did get several, they were acquitted on everything that had to do with a gun, with a firearm, and where the firearm is only alleged. And so obviously there was effectiveness in what they were doing. And so I think when you just addressing it the same way they did the hammer and actually bringing it up, or the same way they did the gun, just actually addressing it, I think that would have been the difference, because we obviously had a jury that paid very close attention. And we see that especially when we see the two jury questions that come back, and they're very perplexed by this hammer. And they're probably, I would submit that they're perplexed by the hammer because there wasn't much on it. And there's nothing on it because trial counsel decided, I'm not going to get anything in writing. I'm going to ignore this email and not act upon it to my client's detriment. I'm going to essentially hope for the best and hope that there is a jury instruction down the line.
So if there wasn't much offered by the state in terms of the hammer being a deadly weapon, what more could trial counsel have done? Yeah, no, you're fine. I understood you to say that the state didn't offer much evidence on the hammer and that the jury probably was perplexed. If there wasn't much evidence on the hammer, what more could trial counsel have done?
I think it's an argument. In your closing arguments, you address it, and you didn't hear anything else about this hammer. And so, again, it's harder for me to place myself right there, but there was obviously some effective counsel happening. There was some defending going on. The problem is that it was only partially. The trial counsel completely ignored the fact that he knew the state was going to try to use the hammer. And what's even more perplexing, which kind of goes to the second issue presented, is that the state immediately starts talking about it in opening arguments in a manner that would suggest we're going to say during this trial that the hammer is a deadly weapon, or the hammer is the article fashioned to look like a deadly weapon.
So in the post-conviction hearing, and you'll forgive me about what's actually contained in the proof, at the post-conviction hearing, was trial counsel asked about why he or she did not argue more specifically about the hammer in closing argument?
I do not believe we got into it that far.
Okay.
And part of that.
So if there's no testimony from counsel about why we're not arguing a question that has almost no proof on it. How is it that you overcome the barrier or the presumption of reasonable representation? How do we overcome maybe the hurdle that this was a strategic call if no one asked trial counsel whether it was or whether it wasn't?
I think going back to what Strickland requires and what the overall test is that we have to, what is reasonable in our profession and what is, I cannot imagine any scenario, even this one, where it appears as though it's struggling to say, well, how could it have been different? How can it ever be reasonable in our profession that we ignore an email that specifically tells us the state is changing its theory of the case on us? I cannot, there is no way that that does not affect the trial in some way.
Well, help me with this. I don't want to, I know judges have other questions too, but one more, just one more question on this. If it is true that the hammer isn't playing that big of a role in the trial, if it's true that by the time we get to the close of the trial, the jury's perplexed about why we're talking about a hammer, what is it the trial counsel would have done? I think maybe that's the hurdle that you could help me with. What more could trial counsel have done at that point? What does it matter if the stipulation wasn't entered? If at trial there's not much proof on it, what more could trial counsel have done?
I think what trial counsel can do is address it, and you can't just ignore it when they're arguing it. You can't just concede that to the jury. And I think by not addressing it at all, you're implying to the jury, it's the hammer. You know, like I have nothing to go on. I can't do anything else with it.
Thank you.
So if I could go ahead, I'll pass it on to my friend.
Thank you. Judge Ayers, thank you very much.
General.
May it please the court, Catherine Redding on behalf of the state. The petitioner has failed to prove his claims of ineffective assistance of counsel. First, petitioner has failed to prove that trial counsel was ineffective for failing to get a written order from the trial court. First, he's failed to prove trial counsel was deficient. Although counsel did testify at the post-conviction hearing that he did not get a written order, petitioner never followed up on that testimony. We have no information in the record as to why counsel didn't get a written order. And as a result, there's no proof indicating whether that was a strategic decision or whether it was just a failure to act. And without proof in the record, the petitioner can't overcome the strong presumption that this court affords to counsel's decisions, the strong presumption that counsel's decision was a reasonable strategic decision. Second, the petitioner can't establish prejudice. So in this situation, a written order, as far as I can tell, would only have said that the trial court found the motion for bill of particulars moot, given the prosecutor's statement. If you look back at the record, what the prosecutor says is, it's my understanding based on the preliminary hearing, I wasn't there, but it's my understanding that it's just the gun. There is no stipulation that the state is only going to rely on the gun. The prosecutor makes it clear, I'm just going off of memory here, and then immediately follows up after the hearing with an email to defense counsel saying, oh, I've gone back and looked at it again. It's clear from the testimony at the preliminary hearing that the hammer is also involved as well.
So it sounds like your friend on the other side, though, is suggesting that trial counsel thought that there was a stipulation. So even if from the state's perspective there actually was no stipulation, in fact, it appears, at least the argument is that trial counsel thought that there was. Isn't it incumbent then upon trial counsel then to more formalize what is going on here? So it's not just an order denying the bill of particulars, but in fact is a stipulation entered into the record that could be enforceable later? Isn't the failure to do that not evidence of deficient performance?
I don't think so, and I think that that kind of goes into the next issue that counsel touched on but didn't really dive into about the claim that defense counsel ignored the state's email. And I guess just to wrap up the first claim about no written ruling, as to the prejudice claim, I am unable to determine what a reasonable probability that the trial outcome would have been different had we had a written order that says this is moot. As the court kind of hinted at, an oral ruling with the transcript carries just as much weight as a written ruling.
Do we have everything we need in the record to determine that issue?
Yes. We have a transcript of the hearing. We have the email that followed up. And mean, given the timing, I'm not sure that an order saying a motion for bill of particulars is moot because the state made this one announcement, given that they followed up, and given how much time there was before trial, that having a written order memorializing the oral ruling would have changed how the trial would have resolved itself. But in any event, to the extent the defendant is claiming that counsel was ineffective for ignoring the state's email, and I mean, to your point, did trial counsel have an obligation to act, to do something?
To memorialize an understanding that trial counsel thought may have existed.
Yes, I think that's an option. But the claim is trial counsel didn't do anything, and that is not supported by the record. Trial counsel did not ignore the state's email. He read the email. He went and did research. He concluded that the state had made the statement. The state had made this, had announced in court that it was planning to rely on the gun. And if the state wanted to change its mind and rely on the hammer, then it was up to the state to bring that to the court's attention. This decision was reasonable given that this stipulation was favorable to the petitioner. I mean, the decision to not really bring the email to the court's attention, that is a decision. That's not ignoring the email, that's a decision. And given the fact that Mr. Emery was seen on video holding a hammer in the immediate aftermath of the offense, I think that it can be counsel made a decision not to bring it up and to hold the state's feet to the fire when it got to trial and force them to basically go along with its first announcement.
Risky proposition.
Yes, but.
So, in a risky proposition, would there have been a duty on the part of counsel to have a plan B? And that is, I'm not going to raise this and hope I can skate on it, but plan B, if it comes up and the state tries to withdraw it, the trial judge allows the withdrawal of what I thought was a stipulation. Now I have my defense that's been prepared. And so what I understand your friend on the other side to say is that there was no backup plan. There was no defense that was prepared in case the trial court changed its mind or the state backed out. How is that not evidence of deficient performance?
Well, I think that we have some initial problems with that particular claim, the petitioner's claim that trial counsel did not prepare a defense. And the first is that he didn't formally raise that in his post-conviction petition. He didn't litigate it at the post-conviction hearing, and the trial court didn't rule on the issue of whether trial counsel was ineffective for failing to prepare a defense. So if we move, it's waived, but even if we move past waiver, the petitioner didn't establish sufficiency. And the reason he didn't establish sufficiency is because he didn't elicit any proof on this at the post-conviction hearing. What was elicited was a comment from counsel that he didn't prepare a defense in that he didn't research whether a hammer can be a deadly weapon or prepare a defense to, quote, attack the concept of a hammer being a deadly weapon. So that's really the only evidence that came in at the post-conviction hearing, and that is rather specific. It's not broad enough to get to the greater concept of preparing a defense for the hammer. And counsel did testify that his defense was to basically hold the state to its quote-unquote stipulation. But I think that even if, as to part plan B,
right,
counsel didn't articulate this, but we can tell from the record that counsel did prepare, his defense for the gun was broad enough to encompass a defense for the hammer, because given that you have video of Mr. Emery in the immediate aftermath of the offense holding a hammer, the way that you say the hammer wasn't a deadly weapon, it was that, not that it is not as a concept a deadly weapon, but that it was not used as a deadly weapon. And the way you attack that is by attacking the witnesses, which was the defense for the gun. And the counsel testified about how the steps that he took to establish a defense for the gun, which was based on attacking the witness's credibility and establishing that they, defendants, basically had an open invitation to enter the victim's residence. So if you establish that they have an open invitation to enter the residence, and then you establish that they're not credible, such that the jury can't believe their testimony that they had a gun, that also takes care of the hammer, because they don't have a gun. If they're not credible, if jury can't believe their claims that the defendants had a gun, they can't believe their claim that they had a hammer. But that also is just trickier by virtue of the fact that there's video evidence of a hammer, whereas there's nothing for a gun. And to the extent that the defendant saying that trial counsel was ineffective for not cross-examining witnesses more about the hammer, that is not something that was in the petition, litigated at the hearing. It's not something the trial court ruled on, and I don't believe it's actually in the briefing. The brief seems to focus more on, it mentions the failure to conduct the legal research on the hammer issue, but doesn't really get into that. But in any event, the petitioner can't prove prejudice either, because as the court has discussed, had counsel done research on whether a hammer is a deadly weapon, it would have found plenty of cases that say a hammer is a deadly weapon. And he can't show a reasonable probability that the outcome would have been different and that he would not have been convicted of aggravated robbery had counsel changed the theory, because the petitioner could have been found guilty of aggravated robbery based on the gun, despite the fact that he was not convicted of the possession. That's a different analysis. It doesn't really affect whether there's a reasonable probability a jury would have just rejected both the gun and the hammer. So, unless this court has any further questions, the state asks this court to affirm the judgment of the trial court. Thank you.
Thank you. Does she have any rebuttal? We'll give you 1 minute for rebuttal. I think you used all of your time before, but.
Thank you.
Yeah, answering Judge Greenholtz's questions. Thank you for doing so.
So just a few things. First, in asking him to memorialize it in some way, that doesn't just have to be the court doing an order of what happened there that day. It also could have been standing there and saying, I am asking the state to go ahead and particularize in writing what it wants to do. That is an option as well. And to say that it is an option to memorialize what happened and what the court said, I don't think that it reasonably can be an option, because if you get a favorable ruling as a defendant in your case before trial, to have something not come in that could harm your client, to not get it memorialized and not have that formalized and ensure that it is rock solid for you, there is no way that is an option. As to holding the state to its stipulation and what the trial court did, again, if it would have been in writing, the court would have had to enforce again that what the court said the state's position was, that the state did not object to, is that the item that appears to be a deadly weapon or is a deadly weapon is the gun. It's not the hammer. And if he would have done that, then counts 3 and 4 would have also had a jury instruction. And again, by not memorializing it and getting that favorable ruling memorialized, he caused prejudice to his client, because his client ended up getting, because the hammer could be considered on counts 3 and 4, they convicted him of the B felony. If not, I think it stands to reason that when they acquitted on a lesser, on the B felony in counts 1 and 2, found him guilty of a Class C felony, if he was only found of a lesser included on counts 3 and 4, he would not be serving the full 15 years, and it wouldn't be the 85% either. So he is certainly serving more time because this instruction was not given on counts 3 and 4. And that did not happen because there was no memorialization. There are no other questions. Thank you.
Thank you.
Thank you.
Thank you again for the attorneys, everybody for being here today. I'll just say on behalf of the court, it's absolutely been a pleasure to be here in this beautiful environment. We appreciate all the work that everyone at UTC and the AOC and our court clerk's office, and especially security. They've taken awesome care of us today and led us around this beautiful labyrinth of a library where we would have been lost and not have made it. So anything you fellows want to add?
I think it's wonderful. Thank you all for appearing here today. Judge Ayers had thanked the university at the beginning this morning, but I love this place. Obviously I'm a graduate of this university. My wife is a graduate of this university. And it really has come through today, not through the work of a couple of individuals, but of scores of people. And so thank you all for attending today and making this a success. I hope that we've brought a little bit of the court into the community, but the community certainly has, we've been enhanced by your participation today.
I'll follow up. It has been a terrific experience, and I want to thank everybody. We usually don't applaud at the end of court, but I think it would be appropriate to thank everybody who did this, and especially Judge Greenholtz.
And for the students, the lawyers have agreed to stay about 10 or 15 minutes and answer any questions you may have of them. The questions could be about the case. Questions could be about their jobs, what they do. It could be about going to law school. It could be any of that. So take advantage of that opportunity. And to our lawyers who've been here all day, thank you all very much for agreeing to do that. You're a critical part of this, and so thank you all. Okay.
All rise.